We now come to the European Withdrawal Bill with consideration of Lord's amendments to the European Union. The Withdrawal Agreement Bill, I must draw the House's attention to the fact that the financial privilege is engaged by Lord's Amendments 1. We'll begin with Government motion to disagree Lord's Amendment 1, with which we will consider the other motions listed on the paper. I call the Minister to move to disagree with the Lord's Amendment 1. To disagree. Secretary of State.
Thank you, Mr. Speaker. It is less than a fortnight since we last debated this bill in this House. Since then, the House of Lords has sat for nearly 40 hours to debate more than 100 amendments. The noble lords in the other place have asked this House to think again on 5 matters, and I will address each in turn. To turn to Lord's Amendment 1 on citizens' rights by the Lord Oates. I know that the noble lords share the government's commitment to putting the rights and welfare of citizens at the heart of our withdrawal negotiations. The first part of this amendment establishes a declaratory system, and the second part requires ministers to bring forward regulations making provisions for those with declaratory rights to apply for a document evidencing their rights. This amendment would mean the successful EU settlement scheme in its current form would need to be abandoned. This is because there would be no need to register if people could later rely on a declaration that they were already in the UK. This would make null and void the 2.8 million applications and the 2.5 million grants of status which have already been completed. Well, in a moment, the government under this amendment would also be unable to issue digital status to EU citizens without also issuing physical documents, including to those already holding a digital status under the current scheme. And this would increase the risk of fraud and raises the issue of costs to government and citizens. Of course, I give way to the Honourable Lady.
Thank you, Mr. Speaker. I'm very grateful to the Minister for giving way. However, he surely is aware that his own ministers have also been stating that it might be possible for people to print off emails, for example, to provide that confirmation. There seems to be a huge number of mixed messages here, and he'll also be aware that many of those citizens are already being asked for that proof by employers. Surely they should deal with the system as it's actually being used, rather than his imagined reality of it, which is rather different.
The Honourable Lady anticipates the next point I was coming on to make in terms of the interplay between a physical document and the digital status, because, as you will know, digital status is more secure than any physical document could ever be. And furthermore, all successful applicants receive a confirmation letter and can download secure share codes, which can be printed or sent to anybody an EU citizen might need to show their status to in the future. So the key is that the number that is there is the best, the digital status is the most secure, but of course people can print off the email that they receive. And the vote to leave included, Mr. Speaker, a desire for greater control of our borders. We need to be able to differentiate between EU citizens who arrived pre-exit and have rights set out in this bill, and EU citizens who arrive after we leave, who will be treated the same as the rest of the world under the forthcoming immigration bill. So despite the good intentions, a declaratory status does not allow for that differentiation, and I therefore urge members to reject this amendment. Of course I could wait.
The Secretary of State for giving way. He will understand that there are, of course, some people for whom the challenge of applying for status is very considerable, and I think the government has said that it will give reasonable consideration to those who have reason not to have applied by the deadline. One group that I and other colleagues are particularly concerned about are children looked after in the care system by local authorities, who don't, in many cases, have either the resources or the expertise to pursue applications for those children to obtain settled status. Can the Secretary of State assure the House that they will be protected as a declaratory system would do?
Lady makes a fair point, and I know it's an issue on which she's taken over many years a very close interest. And she will be aware, firstly, that we've committed £9 million to work with vulnerable groups in order to help those sectors, including the one to which she refers, in terms of using the settlement scheme. She'll also be aware we put a grace period in place to allow additional time if there are reasons why people need to apply late. But the fact is, this is a scheme with no charge and where almost 3 million people have applied. So it is working well, but we have an outreach programme with 57 organisations with money committed to address the point to which she refers. I will now turn to their Lordships' Amendments 2 and 3. Of course, go.
The Government has previously disputed estimates by very respected think tanks that there will be tens and probably hundreds of thousands of EEA nationals who will fail to apply by the deadline and therefore lose their rights. Yep. Has the Government done its own estimate of those numbers? And if it hasn't, how on earth can he dispute those figures?
Well, I think firstly that is in part why the Government has put a grace period in place to address, and it reflects the debate we had in this House on many previous occasions around concerns that the Honourable Member and others raised as to whether people did miss the deadline, and so there is a grace period. But the fact that almost 3 million people have applied is a reflection of the fact that the scheme is actually working very effectively. I'll make just a little progress, then I'll take further interventions. I'll now turn, Mr Speaker, to their Lordships' Amendments 2 and 3 on the interpretation of retained EU law. Amendment 2 by Lord Beith removes the power to set which courts may diverge from retained CJEU case law and how. Amendment 3 by Lord Mackay inserts into the clause a mechanism whereby any court may, where it thinks CJEU case law should be departed from, ask the Supreme Court to decide on that matter. The other place is one of the greatest concentrations of legal talent in the world, and it is only right that the Government's intentions on such a sensitive matter should be examined by their Lordships, including challenging alternatives proposed. The bill ensures time is built in to allow consultation of the senior judiciary in all jurisdictions. And it is worth, Mr Speaker, repeating, as my friends Lord Callan and Keane said, that we will of course also consult with the devolved administrations. The noble and learned Lord Mackay, in proposing Amendment 3, has moved an interesting proposal. But the Government cannot accept this recreation of the CJEU's preliminary reference procedure.
Would my right honourable give way?
Of course.
My right honourable friend, as a fellow lawyer, will know the importance of the doctrine of binding precedent, stare decisis, to our common law system. That was what was seeking to be dealt with by these amendments. If you look at the Hansard in the Lords, it's very clear that we were close to a compromise with Lord Mackay, whereby the necessary scheme to disapply EU law will be dealt with, but will be dealt with with courts of appellate jurisdiction, not necessarily the Supreme Court, but appellate courts. Will he think, again perhaps, that if we don't accept this amendment as it currently stands, the Government will try again to find a compromise when this goes back to the Lords? Because this is a fundamental principle where we ought to be able to find agreement.
Right honourable friend speaks with authority and very constructively in terms of how this issue could be addressed. But let me reassure him that the Government does intend to consider and consult in a rigorous manner to make sure that CJEU case law is properly domesticated after the end of the implementation period. And I'd also like to set out for honourable and especially honourable and learned members that the power in Clause 26 is sunset to the end of the year, the point at which courts will start interpreting retained EU law. I will in a moment. So any change to the rules of interpretation will come in time for litigants and the courts, and we will ensure there is at all times legal clarity on the rules of interpretation. I give way to.
I thank the Secretary of State for giving way, but I stand to support my right honourable friend's proposal of going back to the Lords for compromise on this matter, because I do think of all the changes that have been incorporated into the Withdrawal Act in the last month or two, this is the one which is weakest. It holds open a great deal, a swathe of problems for both government and judiciary, and I think that Lord Mackay got very close to getting it right, and we should talk to him again.
Yeah.
Well, as my predecessor but one, I always listen intently to the constructive points put by my right honourable friend. But I would draw his attention to the fact that we are committed to consulting with the senior judiciary in terms of our approach to this, which I think is the underlying point that the Right Honourable Gentleman is raising. I know the Honourable...
Grateful to him for giving way. He says that he's going to consult with the devolved administrations, but the problem is, at present, the government speaks to the devolved administrations but doesn't take any cognizance of their answer. So can he give me an assurance that when he consults with the devolved administrations on this matter, he will not only listen, but he will actually take on board their advice?
Well, you know, what I'd say to the Honourable Lady, and we had a meeting between ministers and devolved government representatives yesterday in terms of taking on board, as part of our discussions on the next phase of negotiations, the input of the devolved administration. And there have been instances where my counterpart in the Scottish Government has paid tribute, for example, to one of the ministers in the department in the early consultation on the Withdrawal Agreement Bill itself, as the consultation. So I appreciate the Honourable and Learned Lady's position will always be to desire more consultation and for the UK Government to take further note. But it is the case that we are consulting and will continue to do so. But of course I give way a further time.
Grateful to him for giving way again, because it's not that I desire more consultation, it's that I desire the British Government to take on board what the Scottish Government says. Effective consultation, as my honourable and learned friend says. The difficulty is, and the Minister will know this very well, that the Cabinet Secretary, Michael Russell, the senior-most person in the Scottish Government within the British Government deal, is quite clear that he is listened to if he's lucky, but they never take his advice on board.
Well, I think, Mr. Speaker, to say never contradicts comments that Mr. Russell himself has said, but I think the Honourable and Learned Lady has made a point in terms of consultation. I'll make a little bit more progress than I'll take further, but I urge members to reject those two amendments. Turning, Mr. Speaker, to Lord's Amendment 4, which was moved in the other place in the name of the noble Lord Dubs. While the Government humbly disagrees with the noble Lord's amendment, we on these benches recognise the sincerity and the dedication of the noble Lord in relation to this issue and the constructive scrutiny he has provided on behalf of vulnerable children. This amendment removes the provision which amends the 2018 Act to require the Government to report on its policy in relation to unaccompanied asylum-seeking children. I can only say again, Mr. Speaker, as I did in our previous debates, that the Government's policy is unchanged. Delivering on it will not require legislation. The Government has a proud record on supporting, in a moment I will, the Government has a proud record on supporting the most vulnerable children. The UK has granted protection to over 41,000 children since the start of 2010. In 2018, the UK received over 3,000 asylum applications from unaccompanied children, and the UK deals with 15% of all claims in the EU, making us the third highest intake country in Europe. Indeed, the intake in the year ending to September 2019 rose to over 3,500. I give way
for giving way, and I'm pleased that the policy hasn't changed. But why then is he changing the legislation?
Indeed, I mean, again, the Right Honourable Gentleman preempts the passage that I am just coming on to in my remarks. Mr. Speaker, honourable members will be aware that my Right Honourable friend, the Home Secretary, wrote to the European Commission on the 22nd of October on this very issue. This amendment in no way affects our commitment to seeking an agreement with the EU. Primary legislation cannot deliver the best outcomes for these children, as it cannot guarantee that we reach an agreement. And that is why this is ultimately a matter which must be negotiated with the EU, and the Government is committed to seeking the best possible outcome in those negotiations. Give way, and then, of course, the...
Thank you very much. There have been many arguments and debates across this House over the past 3.5 years about the rights of European citizens and about protecting those rights. But surely none of us, regardless of which side of that argument we were on, want to see these children, refugee children, who are amongst the most vulnerable in the world, any question of their safety and the possibility of their being reunited with their families undermined. Why then is the government so determined to take this out of the bill and to not just purely go with the amendment which would guarantee it and would reassure everyone in this House?
Alluded to in terms of this is an issue the Home Secretary is addressing, but of course I could wait to the chair of the or the previous chair of the Home Select Committee. I'm conscious the election is still to come.
Vet Cooper.
The Minister has still given no reason. Why take it out of the 2018 Act? It's in previous legislation. There's loads of things in legislation through the decades that the government says it agrees with, it says it isn't needed because it says it agrees with it, but it doesn't remove it from the statute book. And that is what makes us all suspicious, that he wants to remove it because there's some reason why he thinks it will restrict what he wants to do, and therefore that he's going to, in the end, betray the commitments that have been made to the most vulnerable children of all.
Let me address that head on, Mr. Speaker. The reason is the purpose of this legislation is to implement in domestic law the international agreement we've reached. That is the purpose, and that is what the Withdrawal Bill is doing. That is why we don't support this amendment. But what drives the concern of the Right Honourable Lady is whether the protections will be in place for unaccompanied children. And to that I draw her attention again to the record of this government as one of the three best countries in the EU, as a country, as the figures show, that is the third highest intake country, that deals with 15% of all claims, and that is the policy commitment that the Prime Minister and the government is committed to, and that is reflected in the approach of the Home Secretary. Turning to Lord's amendment, of course, yes.
Very grateful to the Secretary of State. Can I ask him, just at this late stage in the comments that he's making, reflect again on Amendment 4 and indeed Amendment 1. If what he says is true to this House, then there is no principle at stake. If the policy remains the same and the determined will of government remains the same when it comes to unaccompanied child refugees, there's nothing to be lost. And there was no strong defence of the government position in the House of Lords. So I would urge him to consider this matter wholly and listen to voices across this House who believe it would be better to see legislative provision there than not.
I draw the honourable gentleman question to comments I made as to the fact that the policy has not changed and the commitment of this government is reflected in the record, and that is why this amendment should be resisted. Moving on to Lord's Amendment 5, Mr. Speaker, which seeks to recognise the Sewel Convention. The Convention is already found in statute, in the Scotland Act and the Government of Wales Act. However, the Convention in no way limits parliamentary sovereignty. As honourable members will recall from the Miller case, the Sewel Convention is fundamentally political. It was found then not to be justiciable, and to reflect it in the statute should not change that. Of course, I could wait to the...
For giving way. The Prime Minister makes clear that he thinks the Union is important. I think the Union is important too. But it is unprecedented that the Senate, the Scottish Parliament and the Northern Ireland Assembly have refused consent to this bill. And the Welsh Government made very clear in their refusal of that consent that's because the UK Government can potentially force them to accept international obligations in the future relationship, which could impact on devolved competencies. And when we think about things like the NHS, that's going to be absolutely crucial. So will the Secretary of State be clear? Is he going to work with, as well as just meeting and ticking the box, the devolved administrations on those future negotiations, or is he going to impose and therefore generate further conflict and further damage to the Union?
Well, I think the honourable gentleman and I both treasure the Union and want to work to ensure it is preserved. And to address his point, part of the meeting we had with devolved representatives, including the Welsh Government, yesterday, was exactly this point, to hear from them in terms of their input into the next phase. So we are committed to working with the Welsh Government, amongst others, as we shape that negotiation. But as was noted in the other place, Mr. Speaker, it was not quite what this amendment turns on in terms of, as the noble Lord Callaghan said in responding to this amendment yesterday, what matters is that the government continues to uphold the Sewel Convention. And we have done so in the passage of this bill, including ensuring that devolved ministers will have a clear role in the functioning of the Independent Monitoring Authority, particularly in the role in nominating members to its board with specialist devolved expertise. I wrote on the 17th of January to both Mike Russell and Jeremy Miles, my counterparts, on the Scottish and Welsh governments, to make clear that the government's commitment to the legislative consent process and the enduring power and value of our historic partnership. We are, of course, disappointed that the devolved legislatures have nevertheless not consented to this. I'll give one more, but I think the direction from the Chair is to enable other speakers to come in the debate and not to take undue time. So I give one further away, but then I will crack on.
Minister Forward. But given his reference to the letter to the Welsh Government and the Welsh Minister, how does he square the circle in wanting to reinforce the principles of Sewel, etc., on the one hand, but on the other hand, wanting to amend the legislation to withdraw that commitment?
Just help. I'm a little bit bothered about time. We do have quite a few speeches. Can I just remind members, you can't just walk in and do a point, put a question down. Please, let's all work together for each other. Secretary of State.
Thank you, Mr. I was trying to be generous on the interventions, but I will take your direction, of course. But to address the honourable gentleman's point, the devolved government's opposition to BrExit as a whole, we very much respect that decision. But the legislative consent process should not be the place to show such agreements, rather than to voice concerns with the parts of the legislation which relate to devolved competences. The refusal of legislative consent in no way affects the Sewel Convention or the government's dedication to it. However, as recognised by both Mike Russell and Lord Sewell, these are not normal times, and given these circumstances, I urge members, Mr. Speaker, to reject this amendment. Mr. Speaker, we have covered significant ground in debating this bill. Once passed, it will stand as a historic piece of legislation. I therefore beg that this House respectfully disagrees with their Lordships' amendments.
The question is that this House disagrees with Lords in their Amendment 1. Thank them, Debonair.
Thank you, Mr. Speaker, and I rise on behalf of the opposition to explain why we will oppose the government on all 5 of their motions to disagree with their Lordships. Firstly, on EU citizens' rights. Their Lordships passed an amendment providing for, first, a declaratory system for gaining settled status and, second, for a physical document. The declaratory system would honour the previous government's pledges to EU citizens living here before we leave the EU that they would enjoy the exact same rights as before. We're just asking the government to honour that. It would avoid the cliff edge of time limits, and the grace period does still mean a time limit. It would avoid pressures on people who already have the legal right to be here, but for various reasons are being asked for yet more evidence or have not yet been given settled status, but only pre-settled status. The government talks of 2.5 million people granted status, but we know that many of those who've applied for settled status and are entitled to it are granted only pre-settled status, which does not give that promised certainty. Many people aren't aware they need to apply, particularly those here since childhood. Others may not apply in time for many good reasons. And the Secretary of State says late applications for good reasons will be considered, but we don't really know what those good reasons are that will count. So that doesn't give certainty. The Minister argued that declaratory registration is not necessary, the Minister in the other place, because the current scheme addresses all problems, but it doesn't. The arbitrary time limit, the problems and delays in securing status, these all risk making some people who should be lawfully resident, unlawfully resident, past the time limit. The physical document, the other part of the amendment, is vital. We all know, surely in this chamber we all know, that internet signal is not reliable. People don't all have smartphones. Other categories of non-UK citizens have a physical document, so it's not surprising that the Residential Landlords Association say they're deeply concerned about the lack of physical proof and say that landlords are not and should not be treated as border police. I'm sorry, I won't give way until I need to finish this point. In a perverse justification of this policy, the government ministers have actually said that providing a physical document, that this amendment would actually make a future Windrush-style scandal more likely. It's our understanding that it's the exact opposite. I will.
For giving way, and she's making an absolutely crucial point, and she should not agree with me. This was very much the evidence that we heard in the Home Affairs Committee in the last Parliament from experts from that Windrush inquiry that we took place. It was about the importance of physical documents and, of course, that declaratory system issue.
Friend makes exactly the right point, and we ask the honourable members opposite to consider that the Joint Council of the Welfare of Immigrants, the 3 Million and the Residential Landlords Association have all warned, that there is a risk that landlords and employers will be reluctant, without that immediate physical proof that other Windrush citizens lacked, that they will be reluctant to let a home or offer a job to EU citizens. I will give way, yeah.
Mr. Speaker, I do thank the Shadow Minister for giving way. She refers to the poor communications. As I've many times mentioned in this place, in my constituency, they are very, very bad indeed. Broadband is at best indifferent. And therefore, can I suggest to the House that many EU citizens are being disadvantaged in terms of trying to get into the system at all because of where they live.
Yes, the gentleman's absolutely right, but I will now also give way to my right honourable friend.
Very grateful to my friend for giving way. As she will be aware, the Brexit Select Committee in its former incarnation recommended a physical document. There will be many members here who have been through this experience when constituents have applied for further leave. The employer says to them, prove that you have leave. They're told by the Home Office, apply to the checking service. Lots of employers refuse to do that, and as a result, our constituents lose their jobs. Is that not precisely the kind of reason why we need a physical document?
Right honourable friend is exactly right, and I reflect from him and honourable members on this side to the members opposite. Imagine a future constituency surgery in which they are asked to explain to their own constituents, who are EU citizens, why they have been denied a physical document or why they've been denied settled status and experienced delays in getting that status changed, and thus refused a job or a home because their MP refused to back this amendment. Their constituents will ask, why did you vote this way? And they will need a good answer. Secondly, moving on to the CJ EU Amendments 2 and 3. In clause... Oh, if it's... Yes, OK, thank you.
The Honourable Lady will have heard the Minister say that online status was more secure. But of course, in other circumstances, someone with leave to remain here on a spouse visa gets a physical residence permit. If it was more secure, then surely the government would do away with that, but they haven't. And is that not the point? What the Minister said about security is not a justification to oppose Lord's Amendment 1.
Exactly. And that's spot on. I mean, that's why so many of the EU citizens in my constituency say that they feel singled out because they do not have what other non-UK citizens have, which is a physical document. Now, in clause 26 of the bill, the government signals its intention to create chaos and uncertainty in our legal system. I can do no better than quote from the noble Lord Panic, who said that he supported the amendment because, and I quote, clause 26 is fundamentally objectionable because it would give the minister a delegated power to decide which courts should be able to depart from judgments of the Court of Justice and what tests those courts should apply. A minister. He went on, these are powers which step well over the important boundary between the executive and the judiciary. They are matters which should not be decided by ministers. And later he said, and he's absolutely right, once they are conferred, the political and legal constraints, if they decide to act unreasonably, are limited. The government asks us to trust that they won't go beyond existing constraints, but trust that's just not good enough. This provision, clause 26, would lead to different interpretations of the law in higher and lower courts, greater uncertainty and thereby more litigation. That surely can't be what the government wants. So Amendment 2 simply deletes the entire provision. Amendment 3 was a compromise proposed by a Conservative former Lord Chancellor, Lord Mackay. Surely a man that members opposite would want to listen to. And he tried to find a compromise whereby the ministerial right to make regulations would be removed, but instead any court could consider the possibility of departing from case law, but would have to set out their reasons and refer the case to a higher court. What on earth could be the problem with that? I will, yes.
So surely she accepts that ultimately the test and when the courts can diverge from EU law should be set in this Parliament, applied by our courts, and if there's any question, that should be referred to the Supreme Court, thereby maintaining the division between Parliament and the courts.
Yeah, I mean, the problem here really is that we're allowing ministers to set the terms and set the test, and that is an unacceptable breach of the boundaries between the executive and the judiciary. And the government has had plenty of time to consider the provisions of the 2018 Withdrawal Act. If they want more time, just giving ministers broad and sweeping powers is not the answer. They could, if they want, bring a short bill before Parliament, propose amendments. We could debate and scrutinise in the usual way. So every member opposite must understand, and it seems several possibly do, although they're no longer in their place, that if they do pass the government's motion to disagree with amendments 2 and 3 today, the separation of powers will be blurred, there will be legal chaos, and this will be impossible for Parliament to change. These are not powers which should be exercised through regulation. We should not take risks with ministerial interference in judicial processes, Madam Deputy Speaker. The government should think again and withdraw their motions to disagree. If they do not, we will vote against. So thirdly, on child refugees. The Lords' Amendment 4 to leave out Clause 37 of this bill, and Clause 37 amends Clause 17 of the EU Withdrawal Act 2018, thus removing the obligation on the government to negotiate future arrangements to protect unaccompanied child refugees. Now, this is such a modest provision in the first place, and it was the government's own commitment that it does seem extraordinary and inexplicable that they are removing it. And I have very dark and deep suspicions about why. I want to be charitable. I'm hoping that there may be a good answer to this. Now, Lord Dubs said it's partly the scattergun of justifications that leads one to be suspicious. He was asked by the ministers to trust them, so for him to trust them. And he did very generously say that as individuals, he does trust them, but not as a government. Because the government's predecessor government has got form on this, promising to take 3,000 children on the Dubs scheme as originally committed to, and taking fewer than 500 in the end. The government has boasted about the numbers of children, the Secretary of State has done so today, boasted about numbers of children given refuge in this country, but ignoring the fact that most couldn't and did not come by safe or legal routes which currently exist, even when they are entitled to them under current law. They were often trafficked or took dangerous journeys because they felt they had no other choice as a way to reach their family members. We're talking about reuniting families, and removing the already restricted access to safe and legal routes does not increase the risk of trafficking, decrease the risk of trafficking, it increases the risk of trafficking, it increases it. I will give way.
I thank my honourable friend for giving way, and she's making an excellent statement. Does she think that the phrase global Britain means that we stop supporting and giving sanctuaries to some of the most vulnerable people in the world?
Of course not, and honourable members across the other side of the House seem to be agreeing with my honourable friend. But if that's the case, why remove the provision? Why not keep it in? Because the government says there's no change of policy, but removal of Clause 17 is a change of policy. And when they complain that leaving the provision in acts as a pull factor, that does rather indicate that what they want is a change of policy. They tell us that this is not the right legislation for it, that it should be in the immigration bill. But Clause 17 is context and time specific. It directs the government to a negotiating objective for a very time-limited period that they now have to agree the future relationship, a matter of months. We cannot bind our neighbours, as the Secretary of State has said, to national law. So that argument is not valid to putting any other commitment in any other law. This provision is just committing the government to a negotiating aim. They say it can be done through rules. A negotiating aim can't be done through immigration rules. So which is it, Madam Deputy Speaker? Is it law, is it rules, is it an aim, or not a change at all, which they've also claimed? They've said it binds their hands in negotiations, but then became offended at the accusation that they're using children as a bargaining chip. Well, again, which is it? Are children a limit to negotiations or not? They've also justified this on the grounds of the election manifesto, but the only words in that manifesto were, "We will continue to grant asylum and support to refugees fleeing persecution." Not a word in that manifesto which implies this change of policy, and it is a change of policy, on child refugees. Just saying it isn't a change doesn't make it so. Because if it's not a change of policy, why does the provision need to be removed? I will give way.
And the Shadow Minister brings up a hugely important area, and as a former chairman of the All-Party Group Against Human Trafficking, this is a very, very important issue. And I hope the government will commit to come back to us on this, but separate from this bill. I do accept the government's argument. This is the wrong place for this. It's much more important elsewhere.
I mean, I thank the honourable gentleman for that point and for that partly an agreement, I think, that I detected there. But unfortunately, if it isn't acceptable in this legislation, then why in another piece of legislation? It's a negotiating aim, and the negotiations, we are told by the Secretary of State, have already started. Now, to my understanding, all that's happened is that the Home Secretary has written a letter, I think it was in November. We've not yet heard what reply there's been. We've not yet heard about any negotiations. Now, I do not want to believe that this government thinks so little of our country that it's pulling back from protection for a very small number of children that this clause originally covered. I hope, Madam Deputy Speaker, that we as a country are secure enough in ourselves to be generous to those fleeing persecution. And I ask members opposite to consider that this motion demonstrates a lack of compassion. The government's reasons are contradictory. There are no justifications in the manifesto for removing this very modest, limited but necessary provision to protect some of the most vulnerable children we can possibly imagine. And finally, I will. Okay.
Thank you very much for giving way. And I've had a great number of constituents who have been in touch, including my constituent Kirsty, who mentions that her granddad was forced out of Czechoslovakia as a child after World War II and came to the UK as a refugee who was reunited with his parents. And many of my constituents have experience of that family reunion, and they don't understand either why the government would want to roll back on that. Would you agree with me that they really must change their mind on this?
I thank the Honourable Lady for that intervention, because it's just important to get on the record again. It clearly seems to be that we're talking about reuniting children with an adult family relative who is here legally. We're not talking about people who have absolutely no right. We're talking about protecting the requirement to negotiate that. And we really, really ask the government to think again. And if they do not, we will vote against. Yes, I will go for it.
Thank you, Madam Deputy Speaker. And I thank my friend for giving way. Very briefly, just to add to what she said, when it comes to those family relationships, that we also need the government to stick to the principle that it should be an adult to whom they are related to, not just a parent, but an adult to whom they are related.
I thank my honourable friend for that intervention. She's absolutely right, and I do want the government to stick to that commitment. But the government asking us simply to trust them that it will pop up in another bit of legislation is just not good enough. So finally, the Fifth Amendment on devolution. This will be my shortest part of my speech, Madam Deputy Speaker. The Sewel Convention provides that when Parliament wants to legislate on a devolved matter, it will not normally do so without the relevant devolved institution being properly consulted. And all we want is to make sure that that happens. Because our devolved nations need to know, I will in a moment, that government assertions about UK sovereignty in clause 38 of the bill are properly and legally tempered by respect for the law, conventions and practices on devolution, which again seems completely reasonable to us. I'm sure I've heard someone say, yes, sorry.
Does my honourable friend agree with me that despite what the government is saying, the impression is given nevertheless that it wishes to undermine the Sewel Convention by their act of opposing this amendment?
It is indeed the impression that seems to be given. So I ask members opposite, particularly newly elected members opposite representing constituencies in Scotland and Wales, to ask themselves, is this what they told their voters back in November? Did they tell them that they would be voting against respecting devolution? Is that what they said to their constituents? Yes, I will give way.
I'm extremely grateful to the Honourable Lady for giving way. She should be aware, of course, that the Northern Ireland Assembly, the Welsh Senedd and the Scottish Parliament have refused consent. What does it say about the so-called partnership of equals if the three devolved parliaments are completely ignored by the British government?
I think what it would say is that the government will consult, but it's not listening. And I think it's mighty suspicious to notice that that has happened. This refusal to respect this amendment has happened after those devolved legislatures have said that they do not consent. Yes, I will give way.
In an election that talks so much about democracy, isn't it time that this government accepts that democracy is also about listening to our devolved communities? Because that is very much part of democracy, and you cannot just go out, talk about democracy and forget that.
And the right honourable lady is quite right. This is one of the problems we had in the previous iteration of this bill, and even more in this bill. I will give way one more time, and then I must finish.
To acknowledge that the hasty publication of the original EU Withdrawal Act and Clause 11 left a scar because there was a lack of consultation. But the Sewel Convention remains on the statute book. It's not deleting the Sewel Convention from the statute book. We don't repeat everything important in every act in order to just re-emphasise. I mean, it's a kind of virtue signalling that is not necessary to have in this act.
Gentleman thinks that this is already law and we should respect that. Well, why not just accept the amendment? Because also, the original, well, I refer the right honourable gentleman to Clause 38, which this amendment amends. Clause 38 says the somewhat obvious statement that this Parliament is sovereign. Now, Why does that need to be in the bill? Why does that need to be in the Act? Because that's also obvious. So, will the Minister commit, I would like the Secretary of State to commit at some point on the record, that the Government will not bring forward legislation on devolved matters without the proper consultation. And so, in closing, Madam Deputy Speaker, it was a bad bill in October. It's a worse bill now. Amending it is not stopping Brexit. It's about the future, our long-term relationship with our neighbours, and scrutinising and amending legislation, holding the government to account. It seems odd that I have to remind the government, but that is exactly what we are supposed to do in both houses. So I ask members opposite, and particularly those newly elected, do they really think that this is what their voters wanted? Their voters may well have voted for Brexit, and this side, the opposition, accepts that. But did they vote for the government to break trust with the country on child refugees? Did they? Did they vote for the separation of powers between the judiciary and the executive to be blurred? Did they ask for ministers to be given more ability to interfere with the independence of the courts? Did they really vote to treat people who've been here legally for years, who have the legal right to be here, have families and jobs and lives here, to be treated as different as second-class citizens? Did they vote for central government to be able to impose their will on the devolved legislatures? This government has asked us to trust them. And on all of these matters, why should we need to rely on trust? We are lawmakers. Why not include this in the legislation? After all, the Prime Minister has changed his mind many times on many things. Why should we just accept this on trust? So if members opposite think that that's what their electorate voted for, I say they have a dim view of their own voters. And this is now on them, Madam Deputy Speaker. When these provisions unravel, when the consequences emerge, I can absolutely promise that with no pleasure or satisfaction whatsoever, honourable members on this side will be saying to the members on that side, we did warn you, and we will vote against the government today.
Require very short contributions, as there's only 20 minutes left. So for 2 minutes, Sir William Cash.
Thank you, Madam Deputy Speaker. I just simply want to say I concur entirely with what the Secretary of State has said. At the bottom line, and I just want to refer very briefly to Amendment 2 and 3 and 5. First of all, I'd simply say that the government's arguments are completely valid with respect to the question of the lower courts in relation to the Supreme Court. With respect to the question of Lord Mackay's amendment, I think that represents an enormous number of complicated problems which will emerge from it, using expressions such as is of the opinion and the setting out of reasons for the opinion. It's going to create a complete quagmire of interpretation. And so I entirely agree with the government on that. And with respect to the question of Amendment 5 and the issue of conventions, I had the pleasure of advising in relation to the Canadian Constitution back in around 1982. And I had extensive discussions with Mr. Geoffrey Marshall of Queen's College, Oxford, who is the greatest authority on the question of conventions, and I entirely agree with the government's position on this in the light of my own experience of what conventions actually mean, and I have to say I've heard a lot of hogwash this afternoon to the alternative view.
Christine Jardine.
Thank you very much, Madam Deputy Speaker. Can I just say that
SNP front bench. Sorry, it's Christine Jardine first. This is not a second reading debate. Sorry.
Apologies. Can I just say that I fully support the remarks made by the Honourable Member for Bristol West when she said that this is not about trying to refight the argument over Brexit. This is about what is best for the future of the country. And the government did promise in its manifesto just last month, promised voters that the rights of European citizens would be protected. And I would appeal to the members opposite to stand by that, particularly when it comes to those vulnerable children that we have already talked about, who are separated from their families, who are refugees, and who we can reunite legally with families in this country. Why is the government so reticent to put it back in the bill, protect it by law? And finally, one tiny thing on the Sewel Convention. The government says much about protecting the United Kingdom, but I would ask them to consider how often they undermine their own argument, and they tie the hands of those of us on this side of the House who want to protect the United Kingdom, who want to work for the United Kingdom. Because I learned a long time ago that impact is intention, and regardless of your intention over the Sewel Convention, the impact of it is to damage our own argument. So the Liberal Democrats this evening will be opposing the government on this and supporting all 5 of the amendments. Thank you.
On this devolution question, which has been running for ever since the publication of the EU Withdrawal Bill in the summer of 2016, or 2017, I can't remember, there has been an erosion of the trust. And what I plea for, as we have this debate, is that we actually try and build the trust between the different bits of the United Kingdom, which will have to exist even if in some distant future date Scotland became an independent country. The question is, how are we going to rub along together? And I would simply add this particular point about the supremacy of EU law, which is that there is no power grab in any of this, that the powers that are being held by the United Kingdom government are simply the powers that were being held by the European Union since the inception of devolution. And there is some are arguing that there is an implied that the repeal of the European Communities Act means there is an implied power grab from the devolved assemblies if these matters are not automatically transferred back to the assemblies. But these are powers that the devolved assemblies never held. They never held. And in fact, the EU has the power to make international agreements which grabs more power from the devolved assemblies without any consultation whatsoever. So what we have is an improvement of the situation. And what we should try and do, and I understand why these matters become inflamed, is try and not to inflame the division that exists between us on other matters by using this issue, because that is not going to improve the harmony of the relations between this Parliament and the devolved parliaments, or this government, or any government in Westminster and the devolved governments. I appreciate why some might take a different view of that, but that's because they have an agenda which I completely respect, I really do, but this is not the time in this bill to start fomenting those particular issues. Thank you.
Dr. Philippa Whitford.
Thank you very much, Madam Deputy Speaker. The SNP Group supports all 5 Lords' amendments and will therefore be voting against the Government. With regards to a declaratory system, the Secretary of State keeps saying it will make it more confusing, but it makes it a registration rather than an application. And the difference is one is guaranteed to have acceptance. And that's what doesn't exist at the moment. The Government says between 85% and 90% of EU citizens or EEA citizens will get status, settled status, quite easily. But that's 300 to 450,000 people who won't. And if you actually look at those who are struggling, it's particularly people with career breaks, caring responsibilities, and that means it's particularly affecting women. And there's been no sign of an equality impact statement, and there simply should. What's been overlooked is the elderly and frail who've literally been here for decades and decades, maybe even people in care homes or with dementia. And it is wrong to even have the slightest threat hanging over such people who've spent their whole lives here. The physical document is also really important, as has been explained by other members, with regards to dealing with landlords and employers, and particularly because internet is not always accessible. And one of the issues, the Secretary of State said, they can download the email that they are sent that explains their status. It explicitly says this email is not proof of status. It does not provide a document, even if you print it. And I'm sorry, after Windrush, EEA citizens and indeed others don't trust the Home Office not to lose, delete or change their records. Amendments 2 and 3 that relate to Clause 26 is to remove the delegated power of ministers to decide which courts and which test is used to set aside ECJ judgments. This steps away from the principle of precedence. It raises concerns about judicial independence. The government put in their manifesto that they wanted to rebalance power between the executive, Parliament and the courts. And this starts in this bill, and we should be very wary of it. Amendment 4 regarding Lord Dobbs' amendments to restate the government commitment to unaccompanied child refugees. Removing this was probably the things that MPs across all sides of the House were most shocked about and felt that the government simply couldn't justify. At the end of transition, the UK will be outside the Dublin system, and therefore transferring an application for refugee status from one country to another will disappear. Yes. The problem is paragraph 319X of immigration rules is all about the cost of a child coming. It's all about the ability to accommodate them. It absolutely pays no attention whatsoever to what is best for the child. Yes. That's what the Dublin system does. And all this bill or this original clause did was say that the government had to negotiate. And therefore there is absolutely nothing in that that the government should be objecting to. With regards Clause 38 and Amendment 5, absolutely it is unprecedented territory that all three devolved parliaments, so this is not just governments, this is not people who have the same agenda, but parliaments have voted against giving legislative consent. And this government ignores that at their peril. Absolutely. Because people do feel that devolution is threatened after 20 years. Yeah. Not just by this bill, but also by the former changes. Devolution is precious to people, even people who don't support independence. And the government riding roughshod over it really sends a message of disrespect. Yeah. The Prime Minister likes to define himself also as the Minister of the Union. You cannot maintain a relationship or a marriage through force. It has to be based on respect. And if all of this leads to the crumbling of the precious union, he will only have himself to blame.
Mark Harper. Thank you very much, Madam Deputy Speaker. Given the shortness of time, I will limit my remarks to those which I don't think have been made at length before. On Amendment 1, on the declaratory system and the documents, I would simply make 2 points as a former immigration minister. First of all, just on a declaratory system, I do think it's important that we have a system that we currently have which encourages people to establish their status and make sure that's clear now. The lesson I took from Windrush, actually, was one of the problems was that people laboured for many years under the sometimes correct understanding, but often incorrect understanding, that they did have the legal right to be here and they had all the appropriate documents. And then it discovered many years down the line that they didn't, and actually encouraging citizens to European Union citizens to register and establish that certainty now, I think is actually very sensible. And I don't think taking the existing system, which as the Secretary of State says already had 2.5 million successful grants under it, and effectively having to restart that is actually a way of delivering certainty. On Amendment 4, the so-called Dobbs Amendment, the principle that the government is trying to establish, I think, is an important one, and I haven't heard it set out particularly clearly, which is around whether Parliament should legislate for the government's negotiating objectives. That was never the position that was taken by the government in the last Parliament, but the last Parliament, because the government didn't have a majority, forced certain negotiating objectives on the government. I think it's better to re-establish the traditional mechanism where governments negotiate treaties and then they bring those to Parliament for ratification into law. It might sound like a minor point, but I think it's an important point to establish. And it's very clear, the Minister in this House has made it clear, and Lady Williams in the other House has made it clear, the government's policy hasn't changed. And there's a relatively short period of time now until the end of this year, and it is worth, I think, just saying at this point, the Secretary of State's very clear about this, that the European Union has committed in 3 separate paragraphs in the political declaration, they have committed to agreeing our future relationship by the end of this year, as well as us having made that commitment. So I'm very confident that we will have re-established the Dublin regulation in practice by the end of this year, and that's why I firmly support the government in rejecting the amendment. And finally, Madam Deputy Speaker, on the issue about the Sewel Convention. It's already in statute, and I listened carefully to what the Honourable and Learned Lady, who's no longer in her place, the member for Edinburgh, said. But consulting somebody and listening to them and taking into account their views isn't the same as doing what they say. And the problem I have with this is it seems to me that 3 devolved legislatures are simply refighting the Brexit argument all over again. The people of Scotland in 2014 decided for a generation that they wanted to be part of the United Kingdom. And in 2016, the United Kingdom voted to leave the European Union. If the devolved legislatures were accepting that decision and trying to help the government deliver it in a better way, that would be one thing. What they're actually trying to do is refight the battle that's been fought and that they've lost. And on that...
And it's not giving way, but I'm sure he's finishing very soon. Stop it. He's finished.
Last year I visited the camps in Calais and I met some refugee children who were camped in the woods who longed to be reunited with their family members living in the UK. And so these children have fled war and violence, and it's only right that we uphold and afford them our moral duty to have them arrive to the UK safely. And these children are at risk of abuse and exploitation by traffickers, and if the safe routes are not provided, then all this does is make dangerous crossings across the Channel more likely. Now, Amendment 4 puts back what was taken out of the previous withdrawal agreement provisions. So, preserving the rights of refugee children to travel from one EU country to come to the UK after Brexit. Now, the party opposite claim to be the party of the family, yet this policy and their actions exacerbate the division that causes harm and distress and puts these children's rights at risk. I've got no faith in the government that they will protect these rights in other legislation. Their track record on doing anything to support refugee children come to the UK is appalling. And this amendment is in the right place and should be in this bill. This amendment speaks to our humanity as a country, and if this amendment does not pass, then we'll be failing in our moral duty.
Madam Deputy Speaker, I just wanted to set this in the big picture. People voted for Brexit. People voted against last December to get Brexit done. It's taken us 3 and a bit years to reach this stage, and we will be leaving the EU in just a few days' time. And then we have to go very quickly into negotiating the long-term deal. And time again over the past few years, I've heard from EU counterparts say the problem with the British government negotiators is we don't know if they can carry Parliament with them. And it is so important that we send a message to the rest of Europe that what is agreed with the EU can be passed through this Parliament. And that is why it is so important that we take the withdrawal agreement that was agreed and pass it through this Parliament. And yes, there are important things that are raised by these amendments. Of course we want to support child refugees. We always have done. Of course we must make sure the EU citizens' rights, and incidentally, we always will support child refugees. But of course, we must support EU citizens. But the right place to do that is in other legislation and not in this bill.
Yvette Cooper.
Very briefly, the Home Affairs Select Committee in the last Parliament produced a report calling for a declaratory system and also for a physical document. It is possible to have a declaratory system that protects rights, but also an incentive for people to apply and to get the document as well. If all of us in this House were suddenly told that our right to get health care or our right to be able to rent a house or any of those things or to get a job depended on the workings of a Home Office computer system, we would not have confidence in it. And that is why people want to know that there is a a permanent document, I urge him to think again, because this will go wrong. And on the Dubs Amendment, please just accept the Dubs Amendment. Do not put at risk or cast any doubt on this country's commitment to child refugees.
Madam Deputy Speaker, I think we should be thankful that we've got the opportunity to think again on these various matters. I do rather regret there's so little time. Just on this point about a declaratory right, well, in terms of the spirit, of having a declaratory system, I'm very open to it. It would send a wonderful system about how open we are, how welcome people are to stay. But the sheer truth of this is, I say this as the Minister who was responsible for domestic preparedness in the department, it's way too late to be making this decision now. It shows, I'm afraid, rather an ignorance of the way that government systems work. I mean, the whole business of actually delivering a system that can work for literally millions of people, we have to abandon giving status to people, millions of people, if this went through. It needs to be taken out so that we can get on and deliver status for people in a system which is working. On Lord's Amendment to Clause 26, I just point out that the power is sunset to the end of the year. And coming on to the Noble Lord Dubbs Amendment, this is one of those areas where I think we should be very thankful that we're thinking again. But I deeply regret, bearing in mind that it's not long since we heard in this House a general acceptance to the proposition that we're all here to pursue the common good in good faith. I think it's very regrettable that some members have sought to suggest that we would have any lack of commitment to family reunion for refugee children. It's quite wrong. Well, the honourable gentleman says actions speak louder than words. We will earn the respect of the public by delivering.
Order. Under the order of the House of 20th of December, I must now bring to a conclusion proceedings on the Lord's amendments. And I thank everyone who spoke so very briefly. The question is that this House disagrees with the Lords in their Amendment 1. As many as that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. Order! The question is that this House disagrees with the Lords in their Amendment 1. As many as that opinion say aye. Aye. Of the contrary, no. No. Tell us for the ayes, James Morris and Marcus Jones. Tell us for the noes, Jeff Smith and Matt Weston. Lock the doors!
The ayes to the right, 338. The noes to the left, 252.
The ayes to the right, 338. The noes to the left, 252. The ayes have it. The ayes have it. Unlock. Minister to move formally that this House disagrees with the Lords in their Amendment 2. The question is that this House disagrees with the Lords in their Amendment 2. As many as that opinion say aye. Aye. On the contrary, no. Division, clear the lobby. Order. The question is that this House disagrees with the Lords in their Amendment 2. As matters that opinion, say aye. Aye. Of the contrary, no. Tell us for the ayes, James Morris and Marcus Jones. Tell us for the noes, Jeff Smith and Matt Weston. lock the doors. Order! Order!
The ayes to the right, 348. The noes to the left, 246.
The ayes to the right, 348. The noes to the left, 246. The ayes have it. The ayes have it. Unlock. Minister to move formally that this House disagrees with the Lords in their Amendment 3. The question is that this House disagrees with the Lords in their Amendment 3. As many as that opinion say aye. Aye. Of the contrary, no. No. Division. Clear the lobby. Order! The question is that this House disagrees with the Lords in their Amendment 3. As many as that opinion say aye. Aye. Of the contrary, no. No. Tell us for the ayes, Stuart Andrew and Ian Stewart. Tell us for the noes, Jeff Smith and Matt Warman. Weston. lock the doors. Order! Order!
The ayes to the right, 350. The noes to the left, 247.
The ayes to the right, 350. The noes to the left, 247. The ayes have it. The ayes have it. Unlock. Minister to move formally that this House disagrees with the Lords in their Amendment 4. The question is that this House disagrees with the Lords in their Amendment 4. As many as that opinion say aye. Aye. Of the contrary, no. Division, clear the lobby. See the numbers. I absolutely couldn't see it up there. Right, okay, that's fine, thank you. This is Amendment 5, isn't it? Just as well I check. Order! The question is that this House disagrees with the Lords in their Amendment 4. As many as that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Stuart Andrew and Ian Stewart. Tellers for the noes, Jeff Smith and Matt Weston. Anyone going in? Lock the doors! Order! Order!
The ayes to the right, 342. The noes to the left, 254.
The ayes to the right, 342. The noes to the left, 254. The ayes have it. The ayes have it. Unlock. Minister to move formally that this House disagrees with the Lords in their Amendment 5. The question is that this House disagrees with the Lords in their Amendment 5. As many as that opinion say aye. Aye. Of the contrary, no. Division! Clear the lobby. Order! Order. The question is that this House, when I call order during a division, that means everyone sits down or stops so they can hear what is happening. The question is that this House disagrees with the Lords in their Amendment 5. As many as that opinion say aye. Of the contrary, no. Tellers for the ayes, Stuart Andrew and Ian Stewart. Tellers for the noes, Jeff Smith and Matt Weston. unlock the doors. Order! Order!
The ayes to the right, 349. The noes to the left, 246.
The ayes to the right, 349. The noes to the left, 246. So the ayes have it. The ayes have it. Unlock. Minister to move that a committee be appointed to draw up reasons.
I beg to move that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments. that Stephen Barclay, Paul Blomfield, Jack Brereton, Thangam Debonair, Mr Mark Harper, David Rutley, Dr Philippa Whitford be members of the committee, that Stephen Barclay be the chair of the committee, that 3 be the quorum of the committee, that the committee do withdraw immediately.
The question is that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments 1 to 5 to the European Union Withdrawal Agreement Bill. That's Stephen Barclay, Paul Blomfield, Jack Brereton, Thangam Debonair, Mr Mark Harper, David Rutley and Dr Philippa Whitford be members of the committee, that Stephen Barclay be the chair of the committee, that 3 be the quorum of the committee, that the committee do withdraw immediately. As many as that opinion say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it.